Welcome to Harassment Prevention Training for New York. This session will help you understand workplace harassment and how it's handled under New York, state, and New York City laws, as well as federal law. It also meets the mandatory training requirements for both New York State and City. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. Okay, so did you know that more than 60% of people, 60% of employees who face harassment at work never even bother to report it? That's a staggering number considering the millions of workers that exist in the US. And what's even more staggering is even when someone does speak up, they don't see any real change or justice. Well, guys, this creates an additional barrier to harassment prevention. How can you prevent harassment if those people who are speaking up about it don't see the benefit of speaking up? Today, we are talking about how to recognize these behaviors, the right way to report them, and how we can work together to prevent misconduct at work. Because everyone deserves a safe and respectful work environment. This training includes real world examples, legal definitions, and interactive features, so stay engaged and be ready to test your knowledge at the end with a quiz. The content of this video is for informational purposes only. It is not intended as legal advice. Laws and legal requirements regarding harassment prevention can vary by jurisdiction. So, this means you should verify the specific legal requirements that apply to you, to your state, and consult with a qualified attorney if you have any questions or need specific guidance. And just so you know, liking and subscribing is appreciated. Recently, we released videos covering harassment prevention training for both California and Illinois, and each state has its own compliance requirements. As you can see from this slide here, there are key differences between California, Illinois, and New York State. And so today, we're focusing on New York's requirements, but if you're interested in harassment prevention training for California or Illinois, be sure to check out those videos. I've linked them in the description box. In New York State, employers have to provide sexual harassment prevention training to all employees every year. If the state offers a training template in an employee's primary language, the employer also has to make it available in that language as well. Okay, so let's talk about the requirements that employers have on them in the state of New York that also requires them to keep a record of all harassment prevention trainings, including a signed employee acknowledgement. And the employee acknowledgement has to be maintained for at least 3 years, and it has to be made available for inspection if needed. Now, if you're an employer or HR professional that's watching this and you're concerned about compliance requirements, it's important to remember that along with providing the annual harassment prevention training, you'll also need to give your employees a notice that includes the sexual harassment policy that you use at your company, at your organization, and a copy of the training materials if you use them from this video as well. Okay, let's get started with this workplace harassment prevention training. Harassment, discrimination, and retaliation have no business in our businesses. They are, without question, completely unacceptable. In New York State and New York City, there are specific federal, state, and city laws that make it illegal for employers to discriminate against someone, whether it's by refusing to hire them, fire them, or treating them unfairly because of a protected category. So pause the video for a moment and think about this. Okay, so why do you think New York has additional state and city laws that go far beyond federal protections? How might these extra protections impact employees and employers? Share your thoughts about this in the comments below. Okay, so let's walk through the protected categories for New York. They include race, color, sex, gender identity or expression, transgender status, pregnancy, religion or creed, national origin, physical or mental disability, marital or partnership status, age, alien age or citizenship status, veteran status or military status, and employees can also have additional protections under federal, state, or even local laws. So now we're going to take just a few minutes to break down some of these protections so that you have a clear understanding about them. Sexual orientation refers to a person's emotional, romantic, or sexual attraction to others. Gender identity refers to how a person perceives themselves, whether they're male, female, a blend of both, or neither. It may or may not align with the sex they were assigned at birth. There are many gender identities. The most common ways people identify are cisgender, which is a person whose gender identity aligns with the sex they were assigned at birth. Transgender, which is a person whose gender identity is different than the sex they were assigned at birth, or non binary, which is a person who does not identify exclusively as a man or a woman. Some may identify as transgender, but not all do. Gender expression refers to how someone outwardly presents their gender, such as through their clothing or behavior or even their voice. This may or may not align with societal expectations of masculinity or femininity. Transgender is an umbrella term for people whose gender identity or expression differs from societal expectations based on their assigned sex at birth. It's important to remember that being transgender is independent of sexual orientation. Transgender people may identify as straight, gay, lesbian, bisexual, or otherwise. Gender transition is the process that an individual goes through to align their outward appearance with their internal gender identity. Some transition socially by changing their name, pronouns, or appearance, and others undergo medical transitions through treatments and surgery. Gender dysphoria is when someone feels significant distress because their gender identity doesn't match the sex they were assigned at birth. The American Psychiatric Association recognizes this in the DSM, replacing the old term gender identity disorder to better reflect people's experiences. When we say family status, we're talking about a parent or household, people in your house, family related individuals that you would support or connected to, those that you are taking care of, caregiving responsibilities, and domestic partners. But this term family status can also have other meanings, but these are a few examples. Family status discrimination. That happens when employees are treated unfairly because they have caregiving responsibilities for family members. So, race and color are definitely connected, but they are not the same. Race refers to more social categories, those broad categories that we use to talk about people's ethnicity, but color discrimination, that's different. That happens when someone is singled out and treated differently because their skin tone, how much pigmentation they have. In this case, their racial background is not the focus, but it's more of how light or dark or what shade their skin. That's the focus. And under Title VII, protections against race and color discrimination apply to everyone, including Caucasians. Hey, are you still watching? If you find this video helpful, please take a moment to like and subscribe. Your support really helps. Thanks. Creed is all about a person's religious beliefs or their deeply held values, their deeply held beliefs. It's a protected characteristic under anti-discrimination laws in both New York State and New York City. And the protections cover major religions like Christianity, Islam, Judaism, but not just traditional religions like that. Some of the lesser known or non traditional faiths would also be covered. You can't exclude a religion just because it's not well known. If an employee has a strong moral or ethical belief, that is just as important as a religious belief that an employee has. And some of the examples of discrimination under Creed would be an employer, for example, refusing to hire someone because of their religion or denying a reasonable accommodation like prayer breaks or religious attire. Think about turbans and hijabs, things like that, or time off for religious holidays. If an employer were to force an employee to do something that goes against their values, that employee's beliefs, then in that case, it would be covered under creed as well. Harassment is actually a type of discrimination, and it becomes unlawful when someone is singled out or treated poorly because of their race, their age, their gender, or any other legally protected characteristic like those we've just reviewed. When harassment happens because of someone's gender or it involves unwanted sexual behavior, it's considered sexual harassment. Harassment becomes illegal when it leads to unfair treatment at work, like worsened conditions, fewer opportunities, or unequal treatment. Check out the video Ellen Pio versus Kleiner Perkins to learn more about the difference between obvious harassment and subtle forms of discrimination, and why some behavior, even when we can all agree that it's unfair and doesn't feel right, won't always meet the legal standard of discrimination. So, check out the video. The link is in the description. It's important to remember that harassment can show up in many different ways. For example, unwanted advances or inappropriate comments based on sexual desire, bias against a gender like disrespecting women, or reinforcing harmful stereotypes. Abuse of power, where a boss or someone in authority pressures or intimidates employees, making it hard for them to say no. Remember, sexual harassment is also a type of gender discrimination, and gender discrimination is also against the law. Sexual harassment includes unwelcome behavior that's either sexual in nature or directed at someone because of their sex. It's considered harassment when it disrupts someone's work or creates a toxic, intimidating, or offensive environment, even if they aren't the direct target of the harassment. And also, it is made a condition of employment, either directly or indirectly, and accepting or rejecting the behavior impacts someone's job, opportunities, or decisions made about them at work. If you'd like to learn more about harassment prevention and better understand the legal standards required to prove harassment, check out my video. She had 5 pages of evidence, but it wasn't enough. It's a real life case study that clearly shows what's needed and oftentimes what is missing to meet the legal standard for harassment. There are two types of sexual harassment: quid pro quo and hostile work environment. Quid pro quo is a Latin term that means this for that. And sexual harassment occurs when someone, typically a manager or supervisor, someone with control and authority over another person, makes unwelcome sexual advances or makes requests for sexual favors. Going along with this behavior is either required to get or retain the job, or it influences promotions and other work decisions that affect the person. If you want to know more about workplace harassment laws and how they have developed over time and why standing up against harassment is so important, you have to check out my video, The Sexual Harassment Case That Changed Everything. The video shares insight about workplace harassment laws, but it is also a powerful story about the courage one young woman took to make a difference in her workplace that ultimately changed the workplace for all of us. So, what would you do if you overheard a coworker making an inappropriate comment about another employee's appearance? What do you think would be the best way to handle it? Please pause the video, take a moment to think about it, and then share your response in the comments section. Now, let's talk about the key differences between harassment standards in New York versus federal law. Under federal law, harassment has to be severe or pervasive to be considered illegal. But New York and New York City have a lower standard than that. Every situation is different, and there's no clear line between an annoying comment and actual harassment. But according to the human rights law of New York, what really matters is how a reasonable person in the victim's position, would see it, not just whether the comment was meant as a joke. As a result, intent doesn't cancel out harassment. What matters is the impact it has on the person who's experiencing it. Retaliation occurs when an employer takes an adverse action or a negative action, really, against an employee for reporting harassment or participating in an investigation. This not only harms the individual employee, but also discourages others from coming forward, ultimately creating a work culture of fear and silence. Examples of retaliation include being demoted or fired after filing a complaint, a demotion, salary reduction, or unfounded and illegitimate disciplinary actions, having work hours cut for speaking up about misconduct, or even termination. It's important to know that the law protects employees from retaliation, and that helps make sure that when employees do have the courage to speak up or to help out in an investigation, that they're not going to be punished for their efforts to promote a safe and respectful work environment. If you want to know more about retaliation at work, check out my video, Workplace Retaliation. It covers the legal case between the University of Texas Southwestern Medical Center versus Nassar and the retaliation efforts that were taken by the employer in that case and what the court decided as a result of the employer's actions. Employers have a duty to take reasonable steps to prevent discrimination and harassment at work. That means acting quickly and effectively to stop it when it happens and addressing any impact it may have. If someone feels they've experienced harassment, they should immediately check the company's complaint process and let HR or whoever else is designated know about the issue. The company then has an obligation to quickly start an investigation and handle the situation as fairly and confidentially as possible. If you hear about, witness, experience harassment, talk to human resources or management immediately and always write down the details. Make sure someone addresses the situation right away and be ready to help with the investigation by providing facts and details. If you want to know more about subtle signs of workplace harassment, be sure to watch my video, Workplace Retaliation Explained, How Timing Proves It and the Legal Tests to Know, because it breaks down exactly how retaliation claims work, the crucial role timing plays, and the legal standard that courts use to evaluate evidence. Supervisors, they have an obligation to immediately report any complaints of harassment using the method that's been designated by the employer, and they are also obligated to allow the investigation process to play out. No excuses. In New York, the responsibility to fight harassment and discrimination is a shared responsibility. You don't have to be legally required to step in. Anyone can help make the workplace safer. A bystander is someone who witnesses sexual harassment at work, but just being a witness isn't enough. Bystanders can play an important role in creating a workplace that's free from harassment. Here's how: they can offer support to the person who's being harassed, they can speak up and call out the behavior if they feel comfortable doing that. They can interrupt the situation, they can stop it from escalating. They can get help, someone else to intervene, to assist with the circumstances. They can document what happened, what they witnessed, and they can report it. And they can also check in with the victim afterward. When a bystander takes action, it can make a real big difference. It helps reassure the victim that they are not alone and what happened to them isn't okay. Victims often struggle with self doubt. They think, am I the only one who thinks this is wrong? Does anyone else even care? Is there anything I can do to stop it? That's why bystander actions matter. Sometimes something as simple as, that's not okay, or stop it, can send such a strong message. Fighting workplace harassment and discrimination is a shared responsibility, and everyone has a role to play. Check out my video on Twitter's layoff debacle, which unfolded right after Elon Musk purchased the company and rebranded it as X. The video takes a closer look at how systemic harassment ties into gender discrimination and offers a real life look at workplace harassment. So, what should you do if you experience or witness harassment at work? Let's talk about the steps you should take. The first step is to document what has happened. Write down the date, time, and location, what happened, how it made you feel, and save any relevant email, messages, or evidence. If you're comfortable, consider confronting the harasser. In addition to the internal resources made available to employees, there are also external resources that employees can use when they are subjected to unlawful harassment and discrimination. If an employee files an administrative complaint with the New York State Division of Human Rights, the agency will automatically file the complaint with the EEOC to preserve the right to proceed in federal court. If you are outside of New York State, you may have a state or local agency that is an option to you as well. Hey, are you still watching? If you find this video helpful, please take a moment to like and subscribe. Your support really helps. Thanks. In New York, employees generally have up to 1 year to file a complaint about an unlawful discriminatory practice, but for sexual harassment cases, you have up to 3 years. If you choose to file with the New York State Division of Human Rights, they'll also investigate your complaint to see if there's enough evidence to move forward with a hearing before an administrative judge. So you don't need an attorney to file a complaint. If you're in New York and can't resolve a harassment complaint at work, you also have the option to take your case to New York State Court. You have 3 years from the date of the incident to file under the New York State human rights law. Just keep in mind that if you've already filed with an agency, you might not be able to file in court as well. You can file a case directly in state court as long as you haven't already filed with an agency. For more details, you can visit the website that's on the screen. The link is also included in the description. If you're in New York City and you need to file a discrimination or harassment complaint, you can go through the New York City Commission on Human Rights office. The deadline to file is 1 year from the last incident or 3 years if it's a gender-based harassment. You can file a complaint as long as you haven't already taken the issue to court or to another government agency. If you file, the commission will investigate to see if there's enough evidence to move forward with the hearing. For more information, visit the link on the screen or call the 1-800 number that is listed in the description. And of course, if the situation involves things like physical touching, being forced into a space against your will, or forced to perform sex acts, it could be a crime. In those cases, you can always reach out to your local police department for help. Now that we've covered key aspects of workplace harassment prevention, it's time to test your knowledge. Click the link in the description to take the official quiz. Let's review what we've learned today. We talked about what workplace harassment is and how it impacts employees. We talked about different types of harassment, including sexual harassment, bullying, and retaliation. We also discussed employer and employee responsibilities, how to report misconduct, and how to protect your rights. We also discussed the concepts of no retaliation and how to create a safe and respectful workplace. Congratulations, you made it through harassment prevention training for New York State and New York City. By completing this training, you're helping to build a workplace where everyone feels valued and respected. Now, don't forget to take the official quiz and subscribe to the HR Insider for more workplace training videos. If you are looking for general workplace harassment prevention training that meets federal compliance requirements for all states, check out my video, Workplace Harassment Prevention Training, How to Stop Bullying, Discrimination, and Retaliation. It covers really important topics and reviews some of the more key aspects of harassment prevention. Thanks for watching. I'll see you in the next video.